Well, good morning, everybody, and welcome to the latest in our series of DMH Stallard Employment Law podcasts. And I'm very pleased that I'm joined this morning by my colleagues Simon Bellum and Lydia Goodman. And today's topic is how to win ET cases. And Simon and Lydia probably do more tribunal cases than certainly than I do nowadays, and I know a number of my colleagues do. So I'm sure they've got quite a few nuggets for us. I guess probably the first thing, just sort of setting the scene, is thinking about how the tribunals have perhaps changed over the years in terms of how they approach employment tribunal cases. Simon, do you want to help set the scene on that for us, please?
Yeah, tribunals, well, industrial tribunals as they were established in the 1970s, and certainly over the last 30 or 40 years, they've changed a lot. Originally, they were intended to be very informal, and there were no witness statements. There were no employment judges, there were employment chairmen or chairwomen, and there was just a general informality about the processes. And that's changed a lot. And it's now become a very formal legal process with all the bells and whistles of a full court process. The only things that are really missing are the wigs and the gowns, I think. And I think that we have to acknowledge the change when we're preparing for tribunals. We have to acknowledge that you need to be 100% prepared. We have to acknowledge that because it's a more rigid legal process, the tribunal is more likely to stick to the rules and expect us to stick to the rules as well, and our clients. And having said that, I've always said and firmly believe still that the Employment Tribunal's sympathy is a key component in winning tribunal claims. I think that there is still a tendency for tribunals to form a view as to which particular party they sympathise with, whether it's employer or employee. And there's plenty of scope, once they've worked out where their sympathies lie, for them to, if you like, work backwards and then find a way of justifying their decision within those formal legal rules. So critical to maintain the tribunal's sympathy, and that process starts from before you even get to the tribunal. And we're going to talk about that a little bit more as we go through. Having said all that, all litigation has a level of uncertainty with it. You're never guaranteed success. No lawyer will ever say that you're absolutely certain to win. But it's not a lottery, and there's plenty of things that you can be doing which will improve your chances of winning.
I think it's fair to say that over the last sort of 5-10 years, we've seen a bit of an increase in claims as more people are becoming aware of their employment rights. And I think that this is only going to continue to increase following the implementation of and the reform within the Employment Rights Bill. So not only has the bill kind of drawn a lot of publicity and considerable attention to employment rights generally, but we're obviously now going to be seeing the introduction of day one unfair dismissal rights. So I think it's going to be all the more important for employers to keep in mind the processes that they're following and always sort of be alive to potential tribunal proceedings in the future.
I think that's right, although I guess there'll be a slight change of focus and emphasis, but I guess really for some years now, because we've had a 2-year qualifying period for unfair dismissal, increasingly employees have tended to sort of cast about and say, can I bring a discrimination claim? Can I find a protected characteristic that I can rely on? Or can I argue whistleblowing? Both of those, I think, have very much become kind of flavour of the month. So I think employers, whereas probably quite a few years ago, employers, and indeed we would have advised and just sort of said, oh, I haven't got 2 years service, there's probably not much they can do. With the development of anti-discrimination legislation and so many cases around whistleblowing, I think employers are more cautious and do try and kind of work out what their arguments are, really to sort of fill the vacuum and displace otherwise the employee arguing that actually they were discriminated against and that was the underlying reason or part of the reason for the dismissal. Okay, so you've given us some background. Let's look at what we can do to try and improve our chances, and perhaps even before the ET process itself has begun. We've obviously need to make sure that the employer complies with relevant legislation and procedural requirements. But what do each of you think the employer can do to try and improve their chances of successfully defending a claim? Simon, if perhaps I'll ask you first of all.
I mean, I mentioned earlier on the question of the tribunal sympathy, and I think when you are dealing with an employee relations issue, it's critical to remember that whatever you write, whatever you say, may be scrutinised in detail later on in a tribunal setting. So when you're sending correspondence, always keep in mind or ask yourself the question of, well, how will any email or letter that I'm about to send read when it's in front of the tribunal? How will it be interpreted? So always be respectful in tone, be clear in terms of what you're saying, and make sure that you can justify what you're saying. You don't want to be stuck in an employment tribunal under cross-examination and not being able to justify what you wrote in the letter 12 months earlier. Big thing that I think is critical is you mentioned Ruston claims and discrimination claims, and in order to win the case, the employer has got to, if you like, disprove the theory that their decisions were based on whistleblowing or were based on the fact that the employer had made a protected disclosure. So the employer has got to, if you like, prove a negative, that those were not the reasons why it took the decision that they took. Well, the best way of proving a negative is to focus on your positive case for taking a decision. So if you made a decision because of X, Y, and Z, which had nothing to do with an individual's protected characteristic, it had nothing to do with the fact that the individual had previously made a protected disclosure, then the best way of winning the case is to make sure that when you're explaining the reasons for your decision, X, Y, and Z, you do so with absolute clarity and certainty. And that will give yourself the best chances of the tribunal looking at the situation and saying, yeah, we can understand why they did what they did. It had nothing to do with the protected characteristic, nothing to do with the protected disclosure.
Yeah, I think as Simon was saying, that clear reasoning is going to be really, really important. And just kind of piggybacking off that point, I think as part of that clear reasoning, employers need to be ensuring that they're relying on specific evidence to help distinguish those allegations. And they should also be ensuring that they're following ACAS codes and indeed their own internal policies. And I think in that communication, if employers or sort of decision makers are specifically highlighting which part of the ACAS code they're referencing, which policy they're referencing, or which piece of evidence they're relying on, then that way, if the matter ultimately ends up in tribunal in 12 to 18 months' time, not only will an employment judge reading any correspondence relating to a particular decision be able to sort of very easily and readily identify what particular evidence and what particular policies are being relied on, but from a more kind of pragmatic stance, it also means that the evidence is there in black and white for your witnesses, whose memories will, of course, fade in 12 to 18 months' time. And I think particularly when you've got a larger organisation, you may have a witness who's chaired 20 disciplinary hearings that year, for example. So it's the facts of each case will sort of get slightly muddied in their minds. So I think if the evidence is there in black and white, it's going to make the judge's life easier, but it's also going to make your witnesses' lives a lot easier 12 to 18 months down the line.
So you've done, as the employer, pretty much everything that you can in terms of teeing things up properly, but you still find yourself getting a claim. What can you do from the outset? What are the tips from the outset of the employment tribunal process to try and maximise your chances? And maybe, Lydia, if I can ask for your thoughts first of all on that.
So I think the primary consideration is just making sure that you're well prepared. So as soon as you kind of get that notification from ACAS that someone intends to bring a claim and that early conciliation process commences, I think that's a really good chance for employers to sort of start taking stock of the potential complaints that this employee could bring, and just pulling together and familiarising themselves with the key documents that are likely going to be at the heart of the employee's complaint. And that way, once you get their claim form through, once you get the ET1 through, employers, of course, only have 28 days to respond. So that way you're prepared and you can begin pulling together your response. And I think in terms of preparing that response, there are three primary things to keep in mind. So I've already alluded to time, and that 28 days goes very quickly, I think. So time is very much of the essence. And employers can apply to the tribunal for extra time to extend that deadline, but the reality is you're going to want to avoid asking for extra time. There's no certainty that you'll be granted an extension to the deadline, and indeed, in the past, I've seen employers need to have a very good reason to get that extra time. So I think it's advisable to be well prepared and just make sure that as soon as you get that notification from ACAS of early conciliation, to make sure you're carving out sufficient time to make sure you can deal with that response in a timely fashion. Secondly, I think a really good way to score brownie points just from the outset when you're drafting that response is to ensure that you've responded to the kind of most pertinent claims clearly and concisely and chronologically. I think we've always got to bear in mind that the ET3, our response, is going to be one of the first things that the judge reads at final hearing. So you want it to make for easy reading, and you want to give the judge a really clear overview of your position in the case, because that's going to be their first impression. So I think in terms of that, it's just all about keeping everything clear, not getting bogged down in the weeds, particularly if you've got a claimant who's kind of littered their claim form with various allegations that aren't sort of conceivably linked to a claim, and just making sure everything you're saying is accurate too. You don't want to be applying to amend the ET3 at a later date because you've made a mistake. Thirdly, employers need to recognise that this is a really good opportunity to begin evaluating the merits of defending the claim. If it looks like you're onto a bit of a loser, you can sort of start entering into discussions with ACAS or directly with the claimant to kind of settle the claim before you start incurring all the expenses of litigation. But conversely, you might think actually the claimant's really going to have an uphill battle proving these claims, at which point the employer, your organisation, might just take a view that actually you don't want to waste your resources engaging in any kind of settlement discussions, and instead just focus those resources into defending the claim.
Simon, what are your thoughts on this one?
Yeah, I think that the ET3 is a really important document. As Lydia says, it's the first thing, or one of the first things, that the judge and the tribunal panel will read. And I think it's our opportunity to begin to mould their thinking, which ultimately is what we're trying to do. And the argument or discussion, one party might want to be talking about one set of issues, the other party might want to be talking about a different set of issues. And by preparing the ET3 carefully, we can kind of mould the agenda and set out clearly what our agenda is. So the employee may want to talk all about protected characteristics and why they feel aggrieved about the way that they were treated. We in turn will want to talk all about our reasons for the decisions that we took, our standards, our capability processes, our expectations, or in the case of misconduct, what we expect of employees and why the individual's behaviour fell short of that. So it's our ability or our opportunity to set out clearly from the outset, what's important to us, why we took our decisions, and helping to win the claim.
Thank you. Now, we know that there are processes that need to be carried out in the preparation for a hearing. What tips do you each have for our approach to those preparatory steps so as to kind of maximise our chances of a successful outcome? Lydia, I'll ask you again first, if that's okay.
I think once you've got your response filed, one of the earliest steps that you can take to try and help bolster your prospects for a successful outcome is kind of taking control of the claim at the case management hearing. So, and you can sort of start doing this prior to the case management hearing. So typically parties are required to try and agree where possible an agenda for the final hearing, which kind of sets out the amount of days you think the final hearing might need, the amount of witnesses you'll be calling, and also a list of issues which are in dispute between the parties to be determined at that final hearing. So I think it's really important to ensure that both the agenda and the list of issues that you prepare are clear, they're cogent, and they're just easy for the judge to follow. And sometimes it's reasonably easy to agree these with the claimant, particularly if you've got a claimant that's represented, you can keep it quite sensible. But we often see a lot of litigants in person, and I think quite naturally, some are more reluctant to start trying to agree things with their employers or their former employers or lawyers. So I think where you've got a situation where you can't agree to a sensible agenda or a sensible list of issues, it's worth sending through two separate documents. So an agenda for the respondent, an agenda for the claimant, and a list of issues for the claimant and a list of issues for the respondent. And I think if you are able to keep your agenda and your list of issues nice and clear and concise and sensible and sort of going straight to the prominent issues in the case, a judge is going to prefer this, particularly if it's contrasted with a kind of long and lengthy and less coherent agenda or list of issues which has been produced by your opposition. And I think that that can actually just have the effect of alienating an employment judge. So if you can keep yours sensible, I think generally speaking, a judge is going to prefer that, and it's going to give the judge a better overview of the kind of real issues at the heart of the claim. And just sort of staying on this point about the list of issues, it's such an important document because it's effectively going to set the tone of the entire case. It's going to determine what documents you need to disclose. It's going to determine what witnesses you need to call. And it's quite literally the dispute between the parties to be determined at the final hearing. And often I've experienced judges at case management hearings wanting to simply copy and paste a list of issues that I've prepared into their case management order because it's been drafted clearly, because it's concise, because it's sensible. So I think drafting a good list of issues in particular, firstly, makes the judge's life easier at the case management hearing, but it also just can really help you take control of the claim. And just in terms of that control point, I think if you can keep the issues narrow from the outset, where there's sort of less to be determined and it just sort of more goes straight to the heart of the claim, then you've got sort of less exposure to certain risks in a claim. So the claimant's case, forgive me. So the claimant's case obviously needs to be fully advanced in the list of issues, so to avoid applications to amend down the line and consequently a case which is ever changing and evolving. But you don't want the claimant trying to expand their claims beyond those that are in their ET1 and effectively kind of littering the issues, the list of issues with various allegations. So there's a balance to be struck. I once had a case where we'd actually quite happily agreed a relatively simple list of issues with the claimant who was a litigant in person. But then when we got to the hearing, having prepared for the hearing on the basis of that list of issues, the employment judge actually just turned around and said, I think largely because the claim as set out on the list of issues would have been bound to fail. The judge then began trying to explore the claimant's allegations in more depth and ultimately expanded the list of issues on the day. So fortunately, we still succeeded in this claim, but I think it really highlights that although the list of issues is that really important document, tribunals aren't necessarily bound by it. The judge isn't necessarily bound by it. So I think it's really important to just strike a nice balance that accurately reflects the full parameters of the claimant's claim, whilst avoiding having this kind of shopping list of spurious allegations, which is just going to cause further expense in the trial preparation, result in an unduly long hearing, and effectively kind of set all these issues out to be determined, which are going to have very little monetary value, even if they were to succeed in any event. So I think there's a really good balance to be struck, and drafting a list of issues is very much a fine art, but a very important one.
Simon, what about some of the other processes in preparation for a claim? I'm thinking, you sometimes see requests for further and better particulars. Just talk to us about those a little.
Yeah, particularly where we have litigants in person, claimants representing themselves. It's quite often the claim form can be a little bit vague, generalized, and it's quite tempting as a respondent employer to ask for more information. So the sorts of things that I'm thinking about where an employee is alleging that they were overlooked for opportunities or ignored or spoken to rudely, ask the employee to provide detail of each and every occasion when that happened, who was the alleged perpetrator, where, when, etc. And I think you have to be wary of making those sorts of applications. And the main reason for that is that if you ask those sorts of questions, then the huge likelihood is that what you're going to get back in return is a long list of different occasions where X, Y, and Z happened. And you effectively just improve the claimant's case and create clarity in their presentation, which is not necessarily something you want to do. Against that, you don't want to turn up at the tribunal and be surprised by allegations. So it's a fine balance, and I think an assessment has to be made as to, okay, the benefits of finding out more about more of the detail of what the claimant is alleging. I think another interesting process, the conversation so often crops up as one's dealing with a tribunal claim is the question of costs. So generally speaking, the employment tribunal is an environment where neither party will be awarded their costs, even if they're successful. But cost awards can be made, and they can be made where the behaviour of a party or the weakness of their case justifies that. And there are times where a carefully considered letter to the other side threatening to bring a claim for costs in the event that the opponent's claim is unsuccessful is a useful tool, because it creates some pressure on the opponent, some level of financial risk, that if they pursue the claim, if ultimately they're unsuccessful, and if a tribunal ultimately believes that the claim never really stood much of a chance of success, or that their behaviour has been inappropriate in conducting the claim, then a costs award will be made against them. You have to be wary about making those sorts of threats. It can be seen as bullying, and a tribunal might be critical. So again, it's a fine judgment, but certainly it's a potential tool that can create a little bit of pressure on your opponent to withdraw their case and help you win the claim.
Lydia, I think there's another key aspect of the sort of pre-trial preparation or pre-hearing preparation, and that's around documents and disclosure.
The next stage in proceedings, once you've kind of agreed that list of issues, is the disclosure of documents. And it's usually quite an onerous step, particularly for employers, because you've then got to kind of go through every conceivably relevant document in the claim, regardless of whether it helps or hinders your case. And it's I think probably one of the most onerous parts of the tribunal process. And quite often, as part of that disclosure, we might get nothing from the claimant, but conversely, we could get a claimant that discloses hundreds of documents that just simply aren't relevant, without any context, sort of not necessarily following those correct disclosure principles. And sometimes we also get requests from claimants for pretty extensive specific disclosure as well. And sometimes respondents are inclined to dispute these documents, dispute the relevance of these documents, and sort of get into this engagement with the claimant as to why these documents shouldn't be included in the bundle. But I think sometimes it's just far simpler to just say to the claimant, okay, we don't think that all of your documents are relevant, or we don't think the documents you've asked us to disclose are relevant. But what we're going to do is we're going to disclose these documents. We're going to put all of your documents at the end of the bundle in a new section, so that the judge is aware that we don't agree to their relevance. And then what you kind of get is one half of the bundle which is quite orderly, which is easy to follow, it's easy to navigate, and it's got all of the relevant documents in, again, just making the judge's life easier when you get to the final hearing. particularly when it's contrasted with a sort of more irrelevant, more chaotic section of documents towards the end of the bundle, which is going to make the judge's life a lot harder, and which is therefore going to be a lot less compelling for them. They're sort of not going to want to look at that, particularly when they've got your kind of disclosure, your documents that are actually just in an orderly fashion, are actually quite sensible and quite relevant. So I think, a bit like how I was saying, a long list of issues littered with allegations can alienate a judge. I think an overwhelming amount of irrelevant disclosure can also really alienate a judge. So I think if you can just keep yours focused, reasonable, albeit sort of considering that you do need to disclose everything that is relevant. And again, it's a fine balance, like most things are with the tribunal process. But I think if you can just get the bundle right and get the documents right in a sensible, orderly fashion, then that's going to really help the judge when you do get to that final hearing.
And then I guess, Simon, we come to arguably the most important, or certainly the thing that can take a tremendous amount of time to get right, is witness statements. What thoughts have you got on that?
Yeah, absolutely. I think witness statements probably are the most important factor in winning or losing cases. So the first one is a statement of the obvious. Make sure that you've got the right witnesses there, the right people giving evidence. And by that, I mean, you've got to make sure that the decision makers are there. The last thing that you want is for your witness to be giving evidence and for them to be saying, well, I don't know, I can't really answer that because it wasn't my decision. Sometimes it can be a challenge to make sure that people give tribunal proceedings the priority that they need. It can be a chore to devote 2, 3, 4, or maybe even more days to attending a tribunal, but it's really, really important. Witness statements, Lydia mentioned earlier on the importance of the list of issues. Really important that the witness statements address all of the relevant issues as set out in that list of issues, and that they do so in a comprehensive way. We've got to persuade the tribunal of our case, and you don't want to leave gaps or holes in our explanation. It needs to be full and comprehensive. I've often said to clients that what is really important in winning cases is making sure that what you're saying to the tribunal in your evidence resonates with the tribunal. In other words, that as you're speaking, the penny drops with the tribunal and they say, yeah, we can see why you needed to do what you did. We can see why you took the decision that you did. And I think that means that you have to ensure that the witness statements cover those pragmatic and practical points. You know, why was the individual's capability something that was damaging to the business that we could no longer put up with? Don't expect the tribunal just to assume it. You need to explain it very clearly to the tribunal. When you're preparing witness statements, look for any things that might trip up your witness. And the classic example is if there's something that is put in an individual's witness statement that is contradicted or is inconsistent with the contemporaneous documentation. So it's a very careful process to look at what the individual is saying in their witness statement and make sure that it's consistent with what the contemporaneous documentation says, what they were saying at the time. We've talked really in the context of us as lawyers preparing the witness statements on behalf of and the witnesses. Really, really important that witnesses take ownership of their own statements. So you need to make sure that even if we are preparing the witness statements for them, it's based on what they're saying. And very often it's helpful to make sure that this comes across by using the words that the witness would themselves choose to use. It shouldn't be coming across as a very formal legalistic document. It's a statement of what did or didn't happen and why decisions were or weren't made, and it needs to, in terms of tone, make sure that that comes across. Make sure your witnesses are ready for any things that might be put to them in cross-examination. It's pretty rare for a case to not have one or two little things that you're slightly worried about. Make sure your witnesses are aware of those things. Make sure that they have the opportunity in advance, think, okay, if that question's asked of me, how am I going to answer it? Always worth making sure that if there are areas outside of the witness statement that you feel your client or your witness may be asked about, make sure you know what they're going to say in terms of the answer. It's really important that everybody's on the same page. You don't want to be taken by surprise by something that your witness says, because you probably won't have an opportunity to regain your position. So I think it is the most critical area, and those are the things I'd be focusing on in terms of preparing for that.
Thanks, Simon. And really just echoing a couple of the points, I guess, that you made. One is making sure, or you and Didier made, forgive me. One is making sure that you've got the right witnesses. So the most obvious person to speak to a particular hearing or a particular event, or if it's their decision or outcome letter. And then I think the practice, in fact, has changed over the years further. Earlier on, Simon, you said how in the employment tribunal or industrial tribunals, we didn't used to have witness statements at all. And so you weren't always quite sure what at least your opponent's witness was going to say, even if you had no inkling as to what yours own was going to say. And then we had these carefully crafted witness statements. And I think for me, there was probably a good point in that your witness got to read their witness statement aloud. And that would very often kind of help, as it were, almost warm the witness up, get them into their stride. And then when they were asked a question, maybe by the opposing party or by the employment tribunal, they were already kind of in the zone, if I can put it like that. Whereas I think now, because increasingly, or almost as a matter of course, witness statements are, as they say, taken as read. So in other words, the witness doesn't get that sort of warm up and they go straight into cross-examination or straight into a question from the tribunal. And you do sometimes get curveballs in terms of the tribunal asking questions. And I think that can throw witnesses. And they're not sort of, as I say, properly in the zone. And certainly it's happened to me once in my career where my witness was asked a question by the tribunal panel, and she looked across rather plaintively at me and said, "Why did we put that in my statement?" And of course, the case only went downhill from there, unfortunately. But so it really is that bit about making sure the witness, you've got the right witnesses, making sure that they are well prepared. There are obviously very careful rules about what you can do in terms of preparing witnesses and getting them to, or sort of preempting cross-examination questions and things like that, and sort of over-preparing or overly coaching witnesses, but getting the right ones and getting them, as it were, to get in the zone as quickly and as effectively as possible, I think is really important at a hearing. So we're at the hearing, as I say now, we've got the witness statements. What are some practical tips, Didier, that you could give us again to help improve our chances?
So I think both you, Rustam, and Simon have kind of discussed the importance of that witness evidence. And I think preparing sort of coherent, complete witness statements are really important, and just making sure they're an accurate reflection of how your witness remembers events is really important. And second to that, Rustam, you've started to sort of allude to this point, but I think the best way to improve your chances once you've nicely prepared those witness statements, but just before you get to the final hearing, is ensuring that your witnesses are well prepared for what's going to happen on the day. And obviously you do need to avoid that witness coaching, but I think there are several really important steps that you can take to make sure your witnesses are prepared. And I think most importantly, and something employers tend to kind of overlook, is that employment tribunals are of course public hearings. Anyone can sort of turn up and observe. And I think particularly if your witnesses haven't been to a tribunal before and are not therefore au fait with the process, it's really worth contacting your local tribunal office and asking if there are any sort of interesting hearings to attend. Perhaps if you've got a witness who will be giving evidence in a discrimination case, asking the tribunal if there are any discrimination claims that are live, so your witness can go along and have a look. And that way they can just get a flavour for the type of cross-examination questions that could be asked. They get a flavour for how the tribunal operates, how a judge will interact with the witnesses, how a panel will interact with the witnesses. And it can just kind of prepare them as to what to expect on the day. And I think that can help them feel a lot calmer when they're giving evidence, because they know what to expect. They've been to the tribunal before, and they're just that bit more familiar with how proceedings are sort of carried out. And I think in terms of that witness preparation, it's also really good to prepare your witnesses on how to act in court, both when they're giving evidence and when they're just sort of sitting waiting while everyone else is giving evidence. And in terms of giving that evidence, one thing that I do say to witnesses is to, while they're giving that evidence, just watch the judge's pen, or nowadays the judge's fingers on the keyboard. Where you've got a judge that's kind of really writing everything down meticulously, or they're very furiously typing on their keyboard, it's because they think that evidence is important. So I say to witnesses, if you can see that that's happening, just slow down with what you're saying and give the judge time, because you want the judge to really kind of capture what you're saying. And then on the flip side of that, if the judge stops writing, or they just don't seem that interested, then it's probably a good opportunity to stop talking at that point. And then when they're sort of out of the witness box, I think the demeanour of witnesses just sort of sat at the back of the tribunal could go a really long way as well. So you'll want your witnesses to keep a good poker face. You don't want them to be sort of gasping or commenting at the claimant's evidence. It's not a theatre, it's a tribunal. It's serious legal proceedings. So you don't want them sort of talking at the back, causing distractions, and that way the judge can really just focus on the evidence. So I think once you've got your witness evidence prepared, I think the second step is just making sure your witnesses themselves are all thoroughly prepared for the tribunal.
Thanks, Lydia. There's one point just to sort of pick up there, talking about the judge's pen tapping away. And I think it probably belies the fact that despite there being a practice direction, I think a couple of years ago, that all tribunal hearings were to be recorded, that's subject to there being the appropriate facilities in place. And I think it's probably, well, I won't speak for you, but does that happen? Is that happening very often?
I think, generally speaking, all proceedings are recorded, but the transcript of the recording isn't the official note of the hearing. It still remains that the judge's note of the hearing is the official note. So I think actually the judge's pen or the judge typing is still a really important feature in claims.
Thank you. Simon, anything to add? We're at the point of the hearing.
Yeah, just picking up that point in terms of the pace at which you're talking and keeping your eye on the judge's pen. Yeah, I think that generally speaking, there's a tendency when you're giving evidence to feel under pressure and therefore feel rushed. And just remember that it's your opportunity to give your explanation, so take your time. If you're asked a question, pause and think, okay, well, what's my position in relation to that? And then give your answer. Don't feel as though you have to instantly open your mouth without having really thought about your answer. If you think that there's something in the bundle of documentation that could be relevant or helpful to your answer or your reply, take your time to find it in the bundle. The judge will probably give you a hand in identifying where to find it. So don't rush, take your time. I think another practical point, sounds daft, but really important, is making sure that the witnesses are there when they need to be there. We talked earlier on about sometimes it can be a chore to allocate 3, 4, even more days to a tribunal hearing, but it's important that witnesses are there to hear the evidence of the opponent so that they're able to highlight anything that is incorrect about what the opponent is saying, and also to hear the evidence of their fellow witnesses, to hear how they've put things across, to make sure that there's nothing which you as a witness put across which is inconsistent with that. And the last basic point I would make is that although the tribunal day in terms of hours is short, it's typically 10 o'clock till 4 or 4:30. In terms of fatigue, it's long. Because you're listening the whole day, or you might be speaking the whole day, it's tiring, and it's important that You make sure that you're refreshed. So think about what you can take along for the day in terms of nutrition, because I've seen cases which have been lost at 4 o'clock in the afternoon, where the witness is just getting weary and doesn't give the question the right amount of focus and comes out with an answer which just doesn't sit easily with the tribunal. So those practical points, making sure that you allocate the time to be there for the important parts, that when you're there, you're refreshed, that you're behaving sensibly in a way that will give you credit and gain the tribunal's sympathy, are all really important.
Thank you both. Well, that's quite a, I think, tour de force, really, in terms of how we can help ourselves or improve our chances, really, in terms of winning an employment tribunal claim. So thank you both, Lydia Goodman and Simon Bellham, for joining me today. I hope you found, I hope all of the listeners have found the podcast helpful. You can find us on Apple Music and Spotify and wherever you find your podcasts. So until the next time, thank you very much and goodbye.